Assalamualaikum warahmatullahi wabarakatuh. Hello, we are from Group 3 and the topic that we are going to present is Yayasan or foundations. Before we delve deep into it, what is the legal basis of foundations? Well, that is Law number 16 of 2001 as amended by Law number 28 of 2004 regarding about foundations. Well, this law regulates the establishment, arrangement, and objectives of foundations, which included social, religious, and humanitarian purposes. And it also recognizes foundations as legal entities that separates their assets from their founders. Since foundations have existed for a long time, even before the law of foundations was enacted, what was the legal status of foundations before the law was issued? Well, before the law on foundations was enacted, the legal basis for foundations are derived from Supreme Court jurisprudence or jurisprudensi Mahkamah Agung and legal customs, that is conventions. Although there was no specific law regulating foundations at that time, foundations are still recognized as legal entities through a notarial deed, which had to be registered through the district court and announced by the state gazette.
Okay, so now we're going to talk about the purpose of foundation. According to Law number 16 of 2001, which was now revised as Law number 28 of 2004, the purpose of a foundation can be carried out in activities through three main fields. The first one is social purpose. Social purpose mean activities that help society and support social welfare. These activities can be carried out through formal and informal institutions. The examples of formal institutions are like hospitals, nursing homes, or even laboratories. And as for the informal sectors are like course and training centers. The second one is religious purposes. Religious purpose focus on supporting religious activities and institutions such as Islamic boarding school, religious school, madrasah, and other places related to religious education and worship. And the third one is humanitarian purpose. Humanitarian purpose focus on helping people in need. This can include donations, volunteering, and other forms of support. Foundations with this purpose may also help victims of natural disasters, the homeless, and also orphans.
Okay, next I will explain to you what are the characteristics of a foundation. First is a legal entity. One of the main characteristics of a foundation is its status as a legal entity. This means that a foundation must operate under rules and regulations that are officially established by the law. Second is notarial deed as proof of legality. A foundation must also have a notarial deed which serves as official proof of its legality and is also an important document that validates the existence and legitimacy of all activities that are being carried out by the foundation. Third is ownership based on the organization. A foundation is not owned by an individual or a specific person, but rather by the foundation organization itself. This is also reflected in the ownership of its assets and wealth, which are separated from the personal property of its members or founders of the foundations. Fourth, there is non-profit oriented goals. So the main objective of a foundation is generally non-profit in nature. This means that its activities and programs are more focused on serving the community or humanitarian purposes. Lastly is transparency and accountability. Foundations are also required to maintain high levels of transparency and accountability regarding the use of funds and activities that are being carried out. This transparency is essential for building public trust and stakeholders that are involved.
Hello everyone, so now I'm going to talk about the organs of the foundation. According to Article number 1, Paragraph 1 of Law number 16 of 2001, a foundation is a legal entity consisting of separated assets that are intended to achieve certain purposes such as the social, religious, and humanitarian fields that has no members. Then, a foundation is also an independent legal entity. What does that mean exactly? Okay, so a foundation is an independent legal entity or legal subject that does not depend on the existence of the organs of the foundations. It means that the organs of the foundation are not the owners of the foundation, but more like the managers who maintain the continuity of the foundation itself. So, the organs of the foundation are fully responsible for managing the assets of the foundation in order to achieve the purposes and the objectives of the foundation itself. As a legal subject that is not human in carrying out its activities, a foundation requires supporting instruments in the form of organs of the foundation. According to the foundation law, the organs of the foundation consist of three organs. So the first one is the Board of Trustees atau pembina as the highest organ. The second one is the management atau pengurus as the executor and the representative. The third one is the supervisory board or pengawas as the supervisor and the advisor. And now let's talk about each one of them in detail. Okay, so I'm going to talk about the Board of Trustees first. So, as stated in Article number 28, Paragraph 1 of the Foundation Law, the Board of Trustees atau pembina has the highest authority that is not delegated to the management or to the supervisory board, including the decisions regarding amendments to the Articles of Association, appointment and dismissal of the management and the supervisors, and also the determinations of general policies. Next, I'm going to talk about the management. So, as stated in Article number 37 and 38 of the Foundation Law, the management atau pengurus as an organ is obligated to fully carry out the management of the foundation. So, as an organ, the management can both act as the executor and representative. So, the management as the organ of the foundation performs the duties of managing the foundation and also the duties of representing the foundation. The management as the organ of the foundation has the right to represent the foundation both inside and outside of court, including the signing of civil contracts or agreements. Now I'm going to talk about the last one or the third one, which is the supervisory board. So, as stated in Article number 40 of the Foundation Law, the supervisory board has the duty to supervise and to provide advice to the management in carrying out the activities of the foundation. So, the supervisory board can both act as the supervisor and advisor. So, that's all the material for the organs of the foundation. Let's go to the next slide.
The next one is procedure of establishing a foundation, the legal basis. The establishment of a foundation in Indonesia is regulated by Law number 16 of 2001 concerning foundation, and which was later amended by Law number 28 of 2004 concerning the amendment to the foundation law. A foundation is a legal entity formed by separating some assets from the founder for social, religious, or humanitarian purposes, and it does not have members. And a foundation can be established by one person or more by separating part of their assets as the initial capital. It can also be established through a will. There are three stages of establishing a foundation. The first one is establishment stage, legalization stage, and announcement stage. And I'm gonna tell you about the stage 1, establishment stage. The first stage is making a deed of establishment before a notary, and the deed must be written in Indonesian, contain important information about the foundation. The deed of establishment must include several important things, like name and location of the foundation, duration of the foundation, is it limited time or unlimited time, rules about merging or dissolving the foundation, how the foundation obtains and uses its assets, purpose and activities of the foundation, amount of initial assets like money or property from the founder. Next one is rules for appointing, dismissing, and replacing the management, supervisors, and founders. The next one is rules for holding meetings, rules about remaining assets if the foundation is dissolved, and rights and obligation of the management, supervisor, and founders. The establishment stage is the first stage in forming a foundation, and in this stage, the founders must create a notarial deed that contains the identity, purpose, assets, and management rules of the foundation. And this deed will later be used to apply for legal approval from the Minister of Law or Human Rights.
In this slide, I will explain the second step of the legalization stage of a foundation in Indonesia. The legalization of foundation is regulated under the Law Number 16 of 2001 concerning foundations, which was later amended by Law Number 28 of 2004. This law regulates the establishment, management, and legal status of foundation is to ensure accountability and a proper governance. A foundation will only obtain its legal entity status after it receives official approval from the Minister of Law and Human Rights in Indonesia. Without this approval, the foundation is not legally recognized as a legal entity. So there are several steps required to obtain these legalizations. The first, founder of the foundations or their authorized representative must submit an application for legalizations to the Minister of Law and Human Rights. This application must be submitted through a notary. Specifically, the notary would draft the foundation's deed of establishment. And the second step is the notary has an obligation to submit the legalization application to the Minister of Law and Human Rights no later than 10 days after the deed of establishment has been signed. Third, after the application is received, the ministry will review it. The government will then approve or reject the applications within 30 days from the date the request is officially received. If the application is rejected, the reason for the rejection will usually be provided in written form. According to the applicable legal regulations, this legalization process is very important because it ensures that the foundations operates legally and transparently under Indonesian law.
And now, I'm going to explain about the third step, which is the announcement stage. So, once the foundation's deed of the establishment has been officially approved as a legal entity by the Minister of Law and Human Rights, the minister is also required to announce it in the supplement to the State Gazette of the Republic of Indonesia. So, the announcement must be made within a maximum of 14 days from the date of the foundation is approved as a legal entity. And to carry out this announcement, the founders of the foundation must pay an official fee determined by the government. So, for a further explanation, the stage is also important because first, it's public transparency. So the announcement makes the foundation officially known to the public, and anyone can verify that the foundation legally exists. And then the second one is legal certainty. So after being announced, the foundation is fully recognized as a legal entity under Indonesian law. And then the third one will be proof of legality. So the publication in the State Gazette served as an official evidence if there are any legal issues in the future. So in short, even after the approval, the foundation is not considered fully or publicly valid until it is announced by the State Gazette.
So the next one is requirements and required documents for establishing a foundation. The founders must consist of one or more individuals, must allocate a portion of personal assets as the initial capital of the foundation, prohibited from using a name that has already been legally adopted by another foundation, must not conflict with the public order or moral regulation, must have an organizational structure. Legal entity status is obtained after the deed of establishment is approved by appointed official or minister. The establishment must be executed through a notarial deed written in the Indonesian language. The foundation may also establish based on a will. Once the requirements are fulfilled and the deed of establishment has obtained approval and legal entity status, the foundation must apply for a foundation domicile certificate or surat keterangan domisili yayasan, which is a legal document issued by the government, which typically by the local village or urban village office to validate the operational address of the foundation. And the foundation registration certificate or tanda daftar yayasan is an official legal document certifying that the foundation has been registered with the local social service or religious affairs office.
Next is the capital to establish a foundation. So, according to Peraturan Pemerintah Nomor 63 Tahun 2008, the initial capital is divided into two. So, the first one is for local founders with a minimum of 10 million rupiah. As for foreigner founders, or for foreigner founders working with Indonesians, the minimum capital is 100 million rupiah. It is also important to note that the initial amount is not only limited to a form of money, but it can also be in the form of a house where the yayasan or the foundation is established, or the operational equipment, so long as those things are worth at least the minimum amount stated in the statutes.
So, according to the law, foundations in Indonesia can have several purposes. The main types are social, educational, religious, and humanitarian foundations. First of all, we're going to talk about social foundations. So, they focus on helping people in society. Their activities usually include helping poor communities, supporting orphanages, helping elderly people, or providing social services. Second, we're going to jump into educational foundations. They focus on education, obviously, and they usually establish and manage schools, universities, training centers, or scholarships programs. The goal is to improve education and knowledge in society. Third of all is religious foundations. So religious foundations, they focus on religious activities. For example, they manage places of worship, organize religious education, and support religious events in communities. And the last one is the humanitarian foundation. So humanitarian foundation, they focus on helping people in emergency situations or difficult situations. For example, they help disaster victims, they provide medical aid, or support people that are affected by war, poverty, or natural disasters. So from here we can conclude that foundations can have different purposes, but all of them they aim to help society and improve people's welfare.
Alright, next I want to explain about the liquidation of a foundation. First, a liquidation is a process of selling assets or liabilities when a legal entity or business is dissolved. In Article 62 of Law Number 16 of 2001 states that a foundation shall be dissolved if, Section A, the period of time stipulated in Anggaran Dasar has been expired. Section B, the objectives of the foundation as stipulated in Anggaran Dasar has been achieved or cannot be achieved. Section C, a court decision has been obtained a permanent legal force based on the following reasons. First, the foundation violates public order and morality. Second, the foundation is unable to pay its debts after declared bankrupt. Third, the foundation's assets are insufficient to settle its debts after the declaration of bankruptcy has been revoked.
So, I'll be explaining about the utilizations of the foundation assets. First thing first, a foundation uses its wealth or assets, such as money, land, or any property, to carry out its social mission. So, these activities can be in the fields or social services, religion, or even humanitarian work. So these assets are usually used to pay for the daily operations, give the scholarships to any student, and provide health services, and also support the people in need. And the foundation often helps in areas that are difficult for the government or private companies to reach. So the legal rule in Indonesia is there are, especially in the Indonesian civil law, they use the use of the foundation assets. It is regulated by, first is in the law number 16 of 2001, yes, of foundations, and there is the law of 28 of 2004. It's called amendment. So these laws make sure that the foundation assets are only used for its official goals, such as social, religious, and humanitarian. So these assets cannot be used for the personal benefits for someone. For example, the founder of the manager, cannot take the money for themselves. Now, there is the definition of the use of the foundational assets, which means it shows how a foundation use its property or money to achieve the goals written in its founding document. It's written in the Articles of Association. For example, an educational foundation uses its funds to build schools or even give scholarships to any person or any student. And then the second one, a health foundation uses its money to provide free medical treatment, or even a humanitarian foundation uses donations to help a victim of disaster. But there are a few important principle things in using the foundational assets. The first thing is that it's non-profit purposes, which means that a foundation is not meant to make a profit for any individuals. So any income must go back to social programs. And then the second one, it needs transparency and also accountability. So the foundation must clearly report how the money is used so there is no misunderstanding.
There's also an exception when it comes to the usage of foundation's assets. The assets are allowed to be used for administrators' wages and honorarium in a reasonable amount. There are also examples of types of foundations in Indonesia. For example, Dompet Duafa, a foundation that focuses on developing and empowering the people who struggles economically. And for other example, Indonesia Mengajar, a foundation that focuses on distributing education evenly throughout the country, with sending teachers to isolated areas to ensure them that they are getting the education that they deserve.